All right, welcome back. We're on a roll here. We're on to our third panel, and we are delighted to be talking about rapidly developing issues in third-party litigation funding with both people from each side of this conversation, some from the funding side, some from the litigation side. And to lead us in that endeavor, we have Judge Daniel Traynor. Judge Traynor took the bench in January of 2020 on the U.S. District Court for the District of North Dakota. He received his BA and his JD from the University of North Dakota. Upon graduation from law school, Judge Traynor served as a law clerk to Chief Justice Gerald W. Vandervalle of the North Dakota Supreme Court and went into general litigation practice before joining the bench. So with that, I'm going to turn it over to Judge Traynor to lead us through the next panel.
All right, thank you very much. For members of the panel, Daiwai Chin Feman is here. He is the Commercial Litigation Corporate Counsel at Parabellum Capital. He's responsible for the development and execution of Parabellum's commercial litigation investment strategies and has closed dozens of investments from inception to aggregate capital commitments in excess of $450 million. He's one of 3 individuals in the U.S. ranked by Chambers for litigation funding. We also have Tripp Haston here. He's a partner at Bradley, Arant, Boult, Cummings, LLP. He chairs the Life Sciences litigation team and chairs Bradley's litigation team client engagement and advancement efforts. He represents a broad spectrum of clients in regional, national, and international engagements, and he's been recognized nationally and internationally for his life sciences and products liability experience in numerous leading directories. Aviva Wein is here. She's Assistant General Counsel for Products Liability and Group Leader at Johnson & Johnson, and she's an Assistant General Counsel at Johnson & Johnson, where she is the Group Leader of Litigation Policy and Risk Management within the litigation group. And finally, at the end, we have James Burnham. He is the founder and president of Vallecito Capital, LLC. Before that, he was a litigation partner at Jones Day and a senior official in the Department of Justice and also in the Attorney General's Office of the United States. He's a former law clerk for Justice Neil Gorsuch on the United States Supreme Court and also Judge Alex Kozinski on the U.S. Court of Appeals for the Ninth Circuit. And Mr. Burnham and I first met when I saw him debate in an impromptu debate with former Senator Al Franken from Minnesota, who engaged him about some concerns that Senator Franken had with regard to some of the nominees that Mr. Burnham's boss was putting forward to the federal judiciary.
We were right and he was wrong.
but he held his own against Stuart Smalley, which is no small task. So thank you all. But we will start with Mr. Daiwai Chin Feman and have you give some background and information regarding third-party litigation funding.
Thanks so much, Judge. So I work at Parabellum Capital. We're a commercial litigation funder. So I think we're going to hear discussion today about a broad range of things and topics that could be litigation funding. But kind of an initial question, if you zoom out, is what is litigation funding and how do we even define it? Because it could encapsulate everything from borrowing some money from your uncle to do a lawsuit to a defendant seeking to use external capital to defend large multi-district litigation. And so there's a lot of uses. It's really, at heart, it's a risk transfer in litigation. I would say it's been around for decades in various forms, depending on, again, how you label it. So technically, for decades, plaintiffs' firms have been using litigation funding in the form of recourse debt to finance their practices. I would say starting around 15 years ago, the commercial side of the business, so investing in more kind of business-to-business disputes, became a more prominent investment activity for commercial litigation funders. And that's very different from the kind of tort ecosystem, which I'm sure you're all aware of and has its own frustrations. So I just want to say, initially, when you think about this, think about a world where there's kind of the commercial funders, what I do, and then there's the mass tort ecosystem. They're all litigation. There may be similar players who invest in both, but a lot of the considerations that you have for one may not apply to the other. So where I sit, I used to be a lawyer, recovering lawyer. I was at a couple of firms, most recently Dorsey & Whitney in New York. I went to go do litigation funding because I got frustrated, honestly, with lawsuits and having clients, but I got frustrated that, the first 2 weeks of every case I loved, and then I didn't really want to fight with people for the next 5 years. And I thought, oh, these litigation funders, they kind of just focus on the first 2 weeks. I wish that were my job. I do a lot of the first 2 weeks, so high-level assessment of cases, and then my job, unfortunately, is morphed into half kind of transactional lawyer, where I'm actually doing these deals, putting together the contracts, which we're going to discuss here. Generally speaking, litigation funding has grown by leaps and the bounds in the past kind of 10 years as more kind of capital has flown into the space and as more lawyers have found out that it's an option. The bread and butter thing that we do is we finance affirmative litigation, focus on antitrust and breach of contract matters. Our main competitors are contingency fee lawyers. We're generally hunting the same thing. They may be financed by litigation funders as well. We do have a healthy business where we are helping capitalize contingency fee practices so partners can not have to go to a bank to finance that like they normally would. But generally speaking, we're assessing the cases at a high level. There's been a lot more interest in this, and generally it's accepted in the courts that this is a feature now of American litigation. A lot of the discussion focuses on disclosure. So if there's funding, should defendants know about it? Should the courts know about it? I think this is something we're going to discuss a lot today, and my co-panelists all have views, and we come from different viewpoints, and actually I think there is potential for a lot more kind of seeing eye to eye on a lot of these issues, but it is a very complicated thing involving things ranging from state doctrines such as jeopardy and usury and consumer protection laws to issues of disclosure under the federal and state laws, to issues of kind of MDLs and mass torts to the extent the funding is there. And it requires unpacking at a lot of different levels. It's a very complicated topic that the Civil Rules Advisory Committee has been studying since I think 2014 and is still in kind of study mode. They've declined to really do anything on it. Similarly, the Uniform Law Commission also studied it, I think in 2019 or 2020, ultimately declined to do anything or propose a uniform law because there's so many differences state by state with these doctrines such as jeopardy and consumer protection, et cetera. It is still something that's a hot topic for debate, especially as more courts grapple with it. Generally speaking, when courts grapple with it, it's in the context of disclosure. So a defendant will serve discovery requests on a plaintiff seeking to understand facts about their funding. Plaintiffs typically don't want to disclose that for a bevy of reasons, and courts generally have held that the presence of funding and anything related to it, absent special circumstances, which we can discuss, but generally the rule is there's a presumption that this is not relevant to the party's claims and defenses, and even if it were relevant, a lot of the materials at issue in disclosure are subject to work product and other protections. So they're kind of off limits, and there are dozens and dozens of decisions holding that around the country. That doesn't mean that there are instances where there should be disclosure. I think that what we'll discuss, and I'll turn this over to Tripp now, but what we'll discuss is a lot of the things that are driving the urge for disclosure are actually not that objectionable. You're going to hear kind of I'm going to quote from the Vallecito decision in the Third Circuit, a parade of horribles about all the things that could go wrong with litigation funding, and we just don't know what we don't know. And I think the message to take away is there's ways to know a lot of those things. We're in a business here. We're aware of all the criticisms. It would be very silly for us to go about our business, in bed with, say, Russia to control litigation and manipulate the civil justice system. We are here. We know the criticisms. We know that the defendants think that we're, puppet masters pulling the strings in litigation here. It's not true, and we're happy to disclose the information that shows it's not true. But if and only if we have projections against prejudice. So on the commercial side, I won't speak as much about the tort side of funding because I'm not involved in it. But on the commercial side, we are pro-disclosure. The problem is the disclosure that is sought could be very damaging to the litigants' cases that we are funding. We're doing a lot of David versus Goliath litigation here. We exist because people need money for lawsuits. Lawyers are extremely expensive, especially in blue chip litigation. Our average single case investment, which is about 50% of fees and 100% of costs, our average investment is still $6 or $7 million in a single case, and that's for 50% of fees and 100% of costs. Not everyone can afford that. It's a lot, and we're there to help bridge that gap and enable parity and a level playing field in the civil justice system, which I think we all can get behind. But the issue is, if we are funding a case, that doesn't mean that now the defendant should have a whole new line of attack where they say, okay, well, you're funding a case, let me see that funding contract, let me see exactly how much money the plaintiff now has to do the case, let me see what the return is so that I can manipulate the settlement posture. Let me get all of the emails you have with the litigation funder where they ask you about the strengths and the defense of your cases, what you would settle for. There's an entire playbook to a litigation here that the litigation funders need to protect on behalf of the litigants who they are leveling the playing field for. So any disclosure that occurs, if it's accompanied by protection against prejudice, I think you'll find that this could be there could be a pretty easy compromise here that's floated to the Civil Rules Advisory Committee. But if defendants are using disclosure as a means to get things to prejudice a plaintiff's case that otherwise would not be accessible to them, but for the funding, that's where litigation funders and plaintiffs have been pushing back on disclosure because they don't want it to be a Trojan horse to get information that prejudices the cases. However, I think if there were the development of local rules, judges have inherent authority to craft their own, as do courts, or even on a federal level, if there were a proposal for disclosure to confirm things like no judicial conflicts of interest, no undue control, or whatever it is that the defendants seek, or description of the control, production of the contracts with sensitive things redacted, and a presumption against the disclosure of things that could be prejudicial, then I think there will be ample disclosure and it will be mutually beneficial for everybody. But until then, we're in a world where there's presumptions against disclosure because it's irrelevant and privileged, and at the end of the day, could prejudice plaintiffs and their claims. Thank you for indulging me.
The types of investments, the types of lawsuits that you are funding, you view those as investments?
Correct. We're an investment manager regulated in the 1940 Act by the SEC. We have an investment committee, and we're structured like a drawdown private equity fund.
So it is not a non-recourse gift that is provided, or is it a non-recourse investment that if your side of the litigation recovers nothing, you get nothing on?
Correct. It's non-recourse. That doesn't mean it can be breached with impunity. And I think we're going to hear about a case involving Cisco and Burford Capital, which is a litigation funder. I see we've got an article here. I think when that's discussed, I encourage everybody to read the article I wrote in Bloomberg News describing the other side of the story, which is basically, we are non-recourse litigation funders. However, if we invest in a case, that doesn't mean, for instance, that the plaintiff can just take the money and run and walk away, or the lawyers can do the same, right? If we invest in a case, there's a covenant that the plaintiff actually has to pursue the case.
So in the Cisco Buford Capital case, that is the type of investment that your firm would have made?
So we do similar things to the investment that Burford made in Cisco's claims. We have not ended up in a situation like Burford was in. Basically what happened in Burford versus Cisco is Cisco has large antitrust claims in many things, a lot of which are what are called the protein cases. So these are the chicken broilers, pork and beef antitrust cases going on largely in the Seventh Circuit. A new kind of way that, so let me back up. The litigation funding is actually quite a small market. There's probably 7 or 8 companies that really do this in the US. We are, I'd say, the 3rd largest in the US, and we have about 20 employees. Still very small. In terms of deal flow, I've done this year, and I'm one of the largest originators in the industry. I've done less than 5 investments this whole year, just because it's very hard. You have to look very closely. There's so much information asymmetry, and because we don't have control, we need to be very careful about the cases that we do invest in. So they're non-recourse. We don't have the ability to control them. We're not under the protective orders. We're passive. So we need to have a lot of faith that the counterparty, so the plaintiff, is someone we trust, and that is going to settle the cases reasonably. A big problem we have is because we can't control it, folks in the room may be familiar with the inherent self-bias that many litigants have. They think, well, I'll just get on the witness stand, I'll dazzle everyone at trial, they'll all love me, I'll get punitive damages. And we say, please no. We want this case settled as early as possible because we don't want binary trial risk. But a big risk in our business is that folks do take cases to trial because they guarantee they're going to win, and we're kind of on for the ride. So we actually don't invest in a lot of cases if we get the sense that they're going to be trial bets. We only want to invest in things that have a high likelihood of settlement. So in the Burford v. Cisco case, Cisco these numbers might shock you, but Cisco has claims that could be valued in the billions of dollars. Against those claims, and they have a law firm, Boyce Schiller, on contingency. So they actually don't need money for legal spend, and they're Cisco. This is the food company. You see their trucks everywhere. They can afford to pay their lawyers. But what they did was, I think there was a COVID slowdown. They're in a bit of a cash crunch, and they needed some more liquidity. So Burford gave them $140 million against these claims. And they had a covenant to maximize the value of the claims and to litigate them and to not give them away. What happened was Cisco then assigned away, after it received $140 million from Burford, and by the way, when it got the $140 million from Burford did not have any control rights. You're going to hear about that, and I'll give a little primer before they discuss it. Burford had no control rights. What happened was Cisco then, without telling Burford, went and assigned away the majority of its claims. So Burford had given $140 million, and now its collateral, the non-recourse thing that it invested in, has now largely been dissipated. So what did they do? They got in a dispute. Burford said Cisco breached the agreement. They said, we're going to sue you. We're going to give it back. There were a number of things that could have happened at that point, but what they decided as a compromise was Cisco voluntarily said to Burford in this compromise, okay, we're going to settle the claims you have against us because we materially breached the contract, but we understand now that you're worried that the interests aren't aligned because we've given away all of these claims now, and what's to stop us now from settling them for peanuts on the dollar for business reasons or something else? And so they agreed, okay, before there can be any settlement, Burford cannot go and settle these claims. It cannot make settlement proposals. It cannot accept settlements. It cannot control settlement strategy or litigation strategy. But if there's a settlement and the terms are presumptively deemed too low, Burford can veto it, and then we can have an arbitration decide whether or not it was in good faith. And that's exactly what happened, and they went to arbitration, and the arbitrators preliminarily ruled that and said that this veto right does not constitute impermissible control, and Cisco cannot settle these claims for peanuts on the dollar just because it doesn't want to do the litigations that it received $140 million for. In bottom, Cisco got $140 million, was trying to assign away those claims for business reasons, and then tried to exit the litigation and keep the $140 million windfall. What ended up happening was they disputed this, and ultimately, Burford said, you can't settle these for peanuts because that would be in violation of all sorts of duties you have on the contract, duties which existed that aren't even controlled, like the duty to actually do the lawsuit and actually, in good faith, create value from it because you took $140 million from someone. So then what ultimately happened was Cisco caved and ended up assigning all of its claims to Burford. So where are we now is you've got actually a litigation funder who's actually in the claims as a litigant. And now the defendants are claiming that violates state champerty doctrines, which is something that the Seventh Circuit will decide. But that's generally what happened in Burford v. Cisco, is they were given this right only because of a flagrant reach by Cisco, and then Cisco voluntarily decided to give this right, and then contested it and tried to steal $140 million. But again, I encourage everyone, I don't want to monopolize on that. I've written a piece on this which goes through even the academic literature of the expert witness hired by Cisco, where I point out flaws in what she argued, but I give kind of this side of the story because it's important. You may hear people say, we just don't know what we don't know. Look, oh my God, we have one instance here. They had this control. It's like, back up, guys. If control were a prominent feature of litigation funding transactions, we wouldn't all be there saying it's not, because that would be pretty foolish, right? The sun would get shone on us, and I'm out here saying we don't control, and I'll show you that part of my contract. I'm happy to. Same with other litigation funders. Now, there are bad actors everywhere. We can't control that in any space. The final thing I'll leave you with is, to the extent folks call for regulation, there's this parade of horribles. Who knew that looking at legal claims the first 2 weeks like I want to do, and investing in them, who knew it could lead to such a bevy of potential crazy issues? Just think about everything that's identified to you as a potential pitfall of litigation funding. How much of it is independently already unlawful, right? If people are worried that litigation funders are conspiring with Russian interests to manipulate our civil justice system, wouldn't that mean that I am a traitor and I'm in bed with Vladimir Putin? Is that a real line of attack of litigation funders? So just think about all of the criticisms and think about, well, what are we really talking about here? What's really important, and how should this affect what goes on in the courtroom? Thank you.
All right, thank you. Tripp?
Thank you very much, Traynor. Good morning, everybody. I'm glad to be back. I was here last year to speak to everybody. Now, I'm a good bit older than most people in the audience, but I know that there are a few of us of a certain age who remember Paul Harvey. Does anybody remember Paul Harvey? All right, I'm glad that I've got some peers out there. So now I get to talk a little bit about the rest of the story. Let me just sort of level set with everybody in the room, because it's really important for us to understand our audience. And third-party litigation funding is something that we talk about every day. You know, we're kind of nerdy about this subject, but it hasn't completely bubbled up into sort of public or judicial consciousness yet across the board. So how many of you were here last year and may have seen a third-party litigation panel? Okay, a few of you. Okay, good. Well, for those who weren't, I just want to set the stage a little bit, sort of draw the sort of camera back a little bit and set the table for us about what this is and why there are some of us who are concerned about the lack of oversight, the lack of understanding, and the impact it's having on the civil justice system. So, third-party litigation finance, it's a multi-billion-dollar industry. It's inextricably intertwined with our state and federal court system with extremely limited oversight and visibility. It's an industry in which non-parties to a litigation give cash to lawyers or litigants in exchange for a share of the outcome of any resolution in that litigation. And based on several instances in which the funding agreement has been disclosed, we know that these funders often, not always, have a say in the control and direction of the litigation. Though they're not licensed lawyers or counsel of record or parties appearing before a court where they owe a duty to the court. And we're not talking about small dollars here. We have a couple of very sophisticated funders here, and we're talking about a market that exceeds $10 to $15 billion in terms of the money that's in our court system today in civil litigation. And while they act as financiers in civil litigation for purposes of their investments in actual litigation, they're not regulated broadly by anyone in the court system, and there's little sort of financial regulation involved in what they actually do in their individual litigations. And while they fuel and affect litigation in significant ways, again, they're not overseen by any state or federal agency. So the one thing I wanted to talk a little bit today about what's happened since last year. So last year I had the privilege of addressing the audience in the meeting here, and there have been several important developments in the last 12 months that really help sort of understand what's happening in the industry a little bit more. And as a result of those developments, we know a little bit more about the industry, but because there are no current rules broadly that require disclosure of TPLF involvement in an individual case, and there are some exceptions to that rule, there is a push for more disclosure so we can understand what's going on. But because there's not broad disclosure requirements, we don't really know exactly the impact that it's having on our system. We know it's there, we just don't understand the impact. And this was one of the primary reasons that the U.S. General Accountability Office convened a roundtable of 12 experts last year to try and better understand the industry and effects. I was privileged to serve on that panel with other representatives of the funding industry and other academics as well. The obvious solution to understanding TPLF's role in individual cases, as well as our overall system, raised by several GAO roundtable members, including myself, is the routine disclosure in cases so that the court and the parties are aware of the presence and impact of funding. I look forward to talking to you about some of the updates that have happened in the last 4 months. I'm happy to talk about that now, Judge Traynor. Let me just say that. So there are 4 things I want to talk about. The first is the Cisco case that Daiwai mentioned. And not surprisingly, you deal with this every day in court. Parties don't always agree on the interpretation of the same exact thing. The important point to understand about the Cisco case, again, understanding we know so little about what's actually happening. We don't get to see the agreements very often. But one constant thing that we have heard from not all funding representatives, but from several funding representatives, is we don't control settlement. In fact, last year on this panel, if you were here, you might remember there was a Burford panelist sitting next to me. And he actually said, I can't say this any more clearly, we don't control settlements. However, in the Cisco case, there was a lot that went on. But fundamentally what went on is Cisco made a decision, they wanted to settle the case.
And Cisco was the client.
And Cisco was the client that was represented by Boyce Schiller, fine firm, and was funded by Burford. And Burford said, no, you can't settle that. And so we are going to sue you to prevent you from settling that case. And they instituted an international arbitration in London to prevent them from settling the case. And the arbitrable panel in London granted Burford's request. They prevented Cisco from filing, and then what followed thereafter was satellite litigation, both in Illinois and New York, about whether or not Cisco, the client, could settle their own suit. And as Dawai pointed out, it all got resolved eventually. Ultimately, there was an agreement, but the point, not to speed past to the end, the point is funders do in fact control, do in fact influence, and do in fact have impact into settlement and strategy. Not every case and not every funder. Part of the one thing I do want to say that's kind of hopeful is I know that several of us are frustrated with Washington, but our panel may be actually a sign of hope that Washington does work every now and then. We were able to have coffee this morning and sit down, and we'll hope that this will come out. And we do have a broad agreement about certain things, and it's the first time in about 3 years that I've been closely involved in studying this that there is sort of the potential for some agreement about disclosure in particular, and so I'm hopeful about that. So you have the Cisco case, that's one. The second thing that I wanted to mention was third-party litigation funding has been more institutionally set up and sort of involved in other parts of the world, including Australia and the UK. And in the UK, earlier this year, the UK Supreme Court declared it was an individual agreement, individual third-party funding contract, but it declared that contract unenforceable under the laws of the UK. That has sent everybody in the funding industry spinning a little bit to try to fix their contracts. Why do I mention the UK when we're sitting here in the US? I mention it because there's been more oversight, more regulation, more awareness of funding in places like the UK and places like Australia, where you do have a loser pay system. There are barriers to getting into the court that we don't face here at all. And so there's been more oversight than we've had here, and now you've got a very interesting development in the UK where it'll be interesting to see what ultimately happens and what comes out. The third thing I wanted to mention was there's a bill that's been proposed by Senator Kennedy of Louisiana and Senator Manchin, now Senator Manchin, sounds like he may not be forever, along with now House Speaker Johnson. A bipartisan bill that was introduced in September called Protecting Our Courts from Foreign Manipulation. And so one of the things that, again, we have this keyhole that we get to look through to try to understand what's going on in the funding industry. But one of the things that we do understand is that sovereign wealth funds are investing in U.S. litigation. Sovereign wealth funds, these are funds that you probably know are controlled by foreign governments, and they are investing. And the reason we know that is because Burford is the largest funder. They're publicly traded. They have to put out an annual report. It's one of the sources of information we're able to see what's actually happening. And they have disclosed and actually issued press releases about the fact that sovereign wealth funds are investing in litigation. The bill that's been proposed by both the Senate and the House would do several things. It would require disclosure from any foreign person or entity participating in civil litigation as a third-party litigation funder in U.S. federal courts. It would ban sovereign wealth funds and foreign governments from participating in litigation finance as a third-party litigation funder, either directly or indirectly. And it would require the Department of Justice's National Security Division to submit a report on foreign third-party litigation funding throughout the federal judiciary. Now, one of the things that I've heard from people on the other side of this issue is this is a bunch of parade of horribles. This is crazy stuff. We don't have Vladimir Putin or foreign entities investing in litigation. Well, we do know something because it happened in August. In August, down in Delaware, and the district court in Delaware is one of the few courts that has a standing order requiring disclosure of funding. We learned that there is a entity called Purple Vine LP, and I'd encourage you to look this up if you're interested in this at all. Purple Vine is based in Shenzhen, China. I've actually had the pleasure of being there. It's an amazing place. It's basically the Silicon Valley of China. It's just north of Hong Kong. If you get in a car, you drive north, you cross the border, and then you're in Shenzhen. and they are funding IP litigation in the U.S. In IP suits, this particular suit involved Samsung, so we know that there are foreign investors in the U.S., we know that it's an IP litigation, and we know that sovereign wealth funds are here. So that was another important development over the last year. And I think, I have a hard time counting sometimes, but I think those are the 4 things I wanted to talk about. Thank you, Judge.
Tripp, how is this concern about control any different than the control that an insurance company might have with regard to a case that they're defending? They've got a defense obligation, they might have an indemnity obligation, and they're paying for the lawyer on the defense side, and that information is disclosed. I mean, how is this any different? Should the disclosure requirements be the same for funders?
Thank you, Judge. And I think my answer is in part to what you said. We all know that in federal court and in many state courts, you have to disclose insurance, and you have to provide the policy, and you have to provide information to the other side so that the court knows and the parties know about insurance for the litigation at issue. And I think if you went back into the legislative history about that rule, you would probably see these insurers saying that this will be the end of the world, there'll be an invasion of our privacy, of privileged communications, there's going to be all this satellite discovery that takes place because of the production of the policy. Well, none of that happened, right? But what did happen? What happened was that the parties were able to know that there was insurance in the case, and it helped resolve and move litigation through the system quicker. And I think the answer, a big part of the answer here, is to have a similar type of disclosure so that the court and the parties know that there are resources and there is a funder in the case that could have some impact and control. So it's ultimately, Judge, about the fact what the parties know and the court knows about who's in the courtroom and who's actually controlling and driving the litigation.
But there might be occasions where the insurance company becomes a defendant, where their decision-making might be at issue, and that's when you get excess verdicts, you get excess carriers that maybe haven't been communicated with, or the excess carrier is putting pressure on the primary carrier to settle the case. Is this going to be the same type of issue that we might run into in the case of a funder?
Well, it could be, but I think the bottom line is we know so little about the industry and how it works because there is no routine disclosure. One of the things we talked about, and you heard in Daiwai's comments earlier, this industry is not a monolithic industry. There are lots of different types of funders that do lots of different types of things. As Daiwai made clear, he doesn't do a lot of the tort litigation that Aviva and I spend most of our days sort of dealing with. And so I think the answer to your question is it would be helpful for everyone to know more about the industry, more about the entities that are actually involved in these cases, which we simply don't know about today.
Are there occasions where the person in receipt of the funds, for instance, in a case where the funder insists that they go to trial or they have that type of authority or pressure where maybe the plaintiff gets zeroed out, does the plaintiff then have a claim against the funder saying, I had a settlement offer for X and you made me go to trial and I got zero?
It's a fascinating question, and if we knew more about what those contracts provided for and the control that they actually had, well, I would be able to answer that question, but because we see so few contracts, we just don't know.
Just
And
very
Go
briefly.
ahead.
Oh, I would just add to that.
Sure.
You're assuming the actual plaintiff knows that there's a funder involved,
Right? That
Right.
might be the case.
which is wild about this. So when you think about the sanctity of the civil justice system, right, we know who the players are. The plaintiff knows they're represented by counsel, but who does counsel, whose interest is counsel at this juncture, right? Whose interests are they acting in? Because they have a loan they need to repay. So, and the client, the ultimate client, may not know at all, right? And so in whose interest is the funder acting? In whose interest is the lawyer acting? And does the client even know? But I'm happy to talk about it from the in-house perspective.
Can I just say
if you want.
one thing about control? This is an observation, and there's no way for you to verify it, but when the hypothetical you posed about a funder forcing something to go to trial, first, that presupposes the funder would have that ability. I'm not aware of any instance where a funder has that. There's the very different Cisco scenario arising from breach, which I guess you could say caused that to happen because they had a veto right on a settlement. But generally speaking, if funders were able to control, we would be settling cases left and right as early as possible. Litigation is so risky and cases almost universally become worse as things come out and developments happen. So we are pro-settlement, we just don't have the ability to do it. But trial risk is something that we try to avoid at all costs.
Aviva, on to you.
Yeah, thanks. So I'm really happy to be here to provide the insight from the inside, right, from a company who has its fair share of litigation. And we see the effect of third-party litigation funding most significantly and most dramatically in the mass tort space, right? So over the last decade, mass tort litigation has actually been transformed by this funding. It's become a money play. Now, you wouldn't be surprised for me to say to you that, of course, I've always thought it was a money play. But in this case, it's a money play with another actor. And that actor drives funds and distorts the legal system. And so traditionally, right, when we think about tort litigation, it's an individual who's experienced a perceived harm. They seek out a lawyer to vindicate their rights in an effort to recover from somebody who's wrongfully caused that harm. That's how civil justice is supposed to work. But today's mass tort litigation works in reverse. So what we're seeing is that lawyers develop a theory, they develop a tort theory, then they recruit investors, then they use that money to advertise for plaintiffs, and we've all seen that advertisement on TV. Then they haphazardly collect thousands of claims. And what makes that litigation model possible today is the funding. These investors are pouring billions of dollars into the system. I think Tripp said $13 billion of assets are under management, right? And the majority of that funding, one of the groups that advises the funders has said publicly that 70% of the capital is invested in what they call portfolio litigation. That's mass tort litigation. And so I trust you, Dawe, when you say, you know, we wouldn't all be saying there's no control when we wouldn't all be out there saying it, but you're saying it. We just haven't heard anybody else say it, and they aren't all saying that. In fact, they're very quiet about it. These investors, they're piling into litigation funding because they view mass tort litigation as a reliably winning proposition with extraordinary returns. Whether it's settlement, ultimately, or it's some enormous verdict, it does have an extraordinary return. And that vast influx of litigation financing is really reshaping the litigation landscape. What cases are brought, how long they're pursued, when they're settled, yet litigation financing is largely unregulated. It's hidden from courts and parties, including when investors are not control when to settle and for how much. And so breaking it down a little bit more, right? Today's mass tort system goes something like this. Lawyers develop a theory, they recruit investors, they use that money to fund these massive advertising campaigns. They work with paid experts to create junk science. They amass thousands of claims without proper vetting because there is no vetting, and John Beisner touched on this earlier today. They pollute the media, they engage legislators. They even then relatedly get hired by attorneys generals as outside counsel. And they finally seek to extract extortionate settlements from companies. That money that they use, right, in mass tort litigation, the large majority of it is used for advertising on television. And we've all seen that, right? We're bombarded day after day, whether it's television, radio, internet. In 2021, nearly $1 billion was spent on TV ads soliciting people to file lawsuits. So it's not necessarily about access to justice. That's not what we're talking about here. We're talking about manipulating a market for civil litigation.
And these are also instances where the advertising precedes the attorney-client relationship. The advertising is seeking out the clients, and once the client is signed up with the advertiser, then the attorney is engaged, right?
That's right. Right? So it can happen in a number of ways. There's an entire industry around this, right? There are aggregators, people who just do advertising and collect claims, and I've been to these places, they have essentially a warehouse of people sitting at computers, right? It's a call center, just collecting names. They'll then outsource them to other lawyers. They may not even be law firms, right? It's just a business to market and collect names.
So in preparation for this, I contacted one of the plaintiff's lawyers in our little old state of North Dakota. We're a small state with not a lot of people, but occasionally they get somebody who calls into one of these 1-800 numbers and says, I've had an injury of this type. They then need to find a lawyer in North Dakota to take that case. This lawyer told me he tends not to take the case, but they actually charge him $5,000 to take that referral in order to take that plaintiff's case. They charge the plaintiff's lawyer in North Dakota, like a premium.
Yeah, and what's fascinating about that is that the intake folks aren't necessarily vetting the claims.
And
So-
they're not lawyers.
Right, they're not lawyers, and they're not vetting the claim. They don't do any due diligence to see if the person has been exposed to the product, been allegedly injured by the product, but they just buy it and sell it as an asset, right? The Federal Advisory Committee on Civil Rules issued a report estimating that in mass tort litigation, 20 to 30% of cases are meritless, meaning they cannot show product usage or injury resulting from the product. So, I mean, it's just, what it's done is, you have to think about litigation funding in the ecosystem of mass tort litigation. It isn't just the sort of, I think, Dawei, you called it the leveling of a civil justice system. That's not what it's being used for. If you want to talk about litigation funding as funding the actual litigation, so your filing fees, or your expert fees, or your deposition fees, or the lawyer who's actually bringing the case, that's one thing. But what we're talking about is the building of an industry to create a tort, create an advertising campaign, influence the media, influence the government, influence the juries in some cases, because what we've seen is an increase in advertising in veneers where a trial is taking place. So that money is being used for a lot of different things outside just what people like to call access to justice. I think the other thing that you can't take for granted, and it's something we think seriously about, is that we know that the money is being used for these advertisements. We know the advertisements cause harm. In a litigation that I was very deeply involved in, we had doctors who came to us and said our patients were going off a medication because they saw lawyer advertising on a product. And the result was stroke, the result was death. And we went to talk to people about this, right? We went down to talk to anybody who would listen around the effect that these advertisements were having. And the response is, well, there's First Amendment. There absolutely is. It's commercial speech. But you're talking about highly regulated products that haven't necessarily been recalled from the market, that all products have risks and benefits, but the advertising is all about the risks. So you have to think about what this money is being used for. And I think the other thing, and I touched on it a little bit before, is something we don't talk about enough, is the ethical conundrum that the plaintiff lawyer is in. Because the plaintiff lawyer, especially when they get to settlement negotiations, but really throughout the litigation, their self-interest may be in conflict with the interest of the client. Because think about this situation. Plaintiff lawyer takes funding to fund a massive cases, right? And by the way, a lot of the rules that are in place today don't fully understand the structure of the financing, so we'll ask a plaintiff lawyer, do you have funding for this case? They can easily say no, because they don't get funding for a specific case. They get funding for a portfolio of cases. And so a plaintiff lawyer may get an offer of settlement for their client for $100, let's say, right? But they know they have a loan with an interest rate of 20% they've got to pay back. They also know that if they held out for a little bit longer, they probably could, based on what they know about the defendant and their history and things that are going to develop in the case, they probably could get a larger settlement from the defendant. But they also know that if they wait, the interest rate on their loan will double. And so what do I do as a plaintiff lawyer? Whose interests am I working in? So it's something I think that we really need to think about as courts and academics and lawyers as we think about the funding in the context of the mass tort plaintiff business model.
Oh, that was it?
You're
Okay,
up.
Great.
I mean, I can keep
That-
going,
that
but
was
I
like
was
a-
gonna-
that
I was
was like an
thinking-
exclamation point
Before
there.
we get to James, I mean, one of the things to think about is that there are different kinds, different forms and different types of third-party litigation funding. And the ABA did do a third-party litigation funding best practices August 2020 document. But they talked about leaving support for unsophisticated litigants. That's something that plaintiffs' lawyers have been doing for years. They help to pay the rent for somebody who can't afford because of medical problems that they've had. They can't hold down a job, so the lawyer's been supporting them. Investment in commercial litigation, that's what you're talking about. Portfolio funding, that's what Aviva is talking about. There are occasions when somebody's not motivated by profit, so Time's Up is something that was basically started after the Me Too movement to help fund sexual harassment claims for litigants who otherwise wouldn't have funding. Revenge funding, which is the example of that, is the Hulk Hogan versus Gawker case, and you know, where they have a public interest. respondent defendant side funding, that's what plaintiffs' lawyers have been doing to some extent, and then third-party funding and international arbitration. James is just started into a new area.
Yes, sir.
And basically, yours would be basically a cause-based funding, right?
Yeah, it's sort of like ESG, and I can explain, it's actually quite different from ESG, but it's similar to ESG, and I can tell you more about it after this if you want. I don't want to get too sidetracked on the mission. So we just launched in July, and so I'm very happy to be here, and I'm grateful to Judge Traynor for moderating. And I'm new to this, so I'm learning as much as probably everyone in the audience, maybe more, because I didn't come to last year's panel. My background is in public law, so I spent most of my career at Jones Day litigating against the government. Criminal cases, administrative law cases, that kind of thing. I also spent a significant amount of time in the government at the civil division in the last administration defending a lot of lawsuits. We got sued all the time. And so we were often being sued by groups like the ACLU, the NAACP Legal Defense Fund, and even occasionally our good friends at the U.S. Chamber of Commerce Litigation Center, which I've also represented on the private side. Those are all just litigation finance funds. That's what they are. They're groups where some third party gives them money so that they can hire counsel to file lawsuits using that money. No one knows who the third party is. The third party is not a party to the litigation. Nobody knows why the third party did it. Nobody knows why they're giving the money, but they are. And then the group, this public interest group or the Chamber Litigation Center, a trade group, is then filing the litigation. So when I was defending cases against these groups, and as I say, there were an awful lot of them, it never occurred to me to ask, who the donors were that were funding the litigation. It never occurred to me that I needed to inquire about that in order to figure out whether this group and its clients, because they would usually have, human clients that had a claim, who was behind the litigation financially in order to figure out whether it was a strong claim. And honestly, just imagine, just for a second, let's just imagine I had done that. So imagine if when the ACLU, representing some people, had sued to stop the building of the border wall, which is a case that I defended in multiple district courts, multiple circuit courts. Now imagine that I had sent some subpoenas and some interrogatories demanding to know who was funding the litigation on behalf of the ACLU. Is the Chinese Communist Party funding this ACLU litigation against the Trump administration to undermine U.S. border security? I don't think it would have gone well, and not just because I was in the Northern District of California. I think most people would have said, what are you talking about? The issue in the case is whether these people have a legit claim against the administration, not whether there's some, boogeyman behind the curtain who's funding it. And so I think, to me, that is sort of how I approach all of these issues, in part just because that's the experience that I've had. So as far as I can tell, litigation finance, like we're talking about here, is really no different than any of that. The only difference, and we can talk about whether it's a difference with a distinction, is that the investor has a pecuniary interest in the outcome rather than an ideological or some other business interest in the outcome, as in the examples I gave. Also, it's been said a few times, I think, that it's totally unregulated. I don't understand that argument either. It's highly regulated. The lawyers remain the key players in the system. The lawyers are highly regulated. We have members of state Supreme Courts here. The lawyers are all regulated by your bodies and the bar associations beneath them. And if lawyers are lying to their clients, or they're breaching their duties to their clients, or they're not telling them about things, those lawyers should face serious disciplinary sanctions and maybe even get disbarred. That's already a regulatory system that exists. In terms of the balance of power, so look, as we all know, defendants, and particularly large corporate defendants, generally have more money and more resources than individual plaintiffs. That's the whole point of the contingent fee. And many of the same arguments you're hearing today about why lit finance is bad are the exact same arguments people have made about contingent fees for 100 years or 80 years, however long it's been that we've had them. The lawyer has a pecuniary interest in the outcome. That can create divergences. If the lawyer can settle early after spending 10 hours and make $100,000, he or she is likelier to want to do that than settle later after 1,000 hours to get 200,000. Same points. I actually think litigation finance lessens the tension, right? So if the plaintiff's lawyer has a second mortgage on the home, particularly with current interest rates, that lawyer is going to feel a lot of pressure to monetize the case as fast as possible. If the lawyer has a non-recourse lending product where the case goes south, lawyer doesn't have to pay anything back, doesn't lose the house. It actually, I think, aligns the interest better with the plaintiff. Another benefit of litigation finance that I think about a lot, because I have a lot of friends who either served in the last administration or are maybe getting tired of working at large law firms, is that litigation finance can actually facilitate entry into the plaintiff's bar by outstanding lawyers who are not starting out with the huge amounts of capital you need in order to basically build a plaintiff's firm. You know, I'm new to this, but my understanding is the traditional model is you either go work at a Motley Rice or somewhere like that, and a lot of my friends probably aren't super aligned with them on a lot of issues, and you don't make very much until you get your first big hit, and then at that point, you know, things are a little stable. But that can take 5, 6, 7, or 8 years. And so one of the things lit finance can do is help these lawyers, some of whom may come from non-traditional backgrounds, maybe they don't have a lot of money, monetize earlier and have a smoother path. And I think that's a good thing for the legal system to have more good lawyers on all sides. You know, we've talked a lot already about the degree to which the funder can interfere with the attorney-client relationship. All I would say is that, you know, that interfering with the way the case proceeds is what you hire defense counsel to do, okay? All defense counsel want to do is impede the resolution of the claims as much as possible so that the case goes away. That's what a good defense lawyer does. And that usually involves racking up lots and lots and lots of busy work in order to grind down the other side and hopefully get a good outcome for the client, which is, of course, their job. And I'm not blaming them for that. I'm just saying that's the way it works. And in fact, if you really want to talk about incentives to waste time, I mean, let's talk about the billable hour. You know, I was just at a large law firm. You've got everybody running around trying to hit their 2,000 hours a year. Boy, those letters, staying up late one night, having the associates write 16 letters to the other side starts to make a lot of sense when the entire economic model is literally based on wasting time. That's the whole point. The faster you resolve something on the defense side, the sooner you're looking around the room and sending emails to all your friends that are in-house, asking them if they have any projects for you to do. So, you know, most people on the defense side are quite happy to have it go as long as the client will let them. The client is often happy to have that happen because sometimes it will work and you can basically just win the war of attrition, and the case will just go away. And then the last, I just want to touch two more things and then I'll yield back. There is a lot of potential for harassment and litigation, I think exacerbated by the billable hour because there's so much of an incentive to spend a lot of time on discovery. This is what makes me nervous about disclosure rules, right? I mean, let's get real. Like, as soon as there's any sort of disclosure requirement, there's going to be a phalanx of associates from Skadden sitting in the basement all night, writing letters, writing subpoenas, writing let's find out who the funder is, let's find out where they live, you know, what is going on here, with this, the Chinese might be involved. I mean, it's going to be a whole thing that's going to be a sideshow. It will consume a ton of time. So I have no problem, I think, in the abstract with some sort of limited disclosure requirement, but what I am worried about is that it will just become a major time-consuming exercise that, among other problems, functions as a tax on anybody who's using a litigation finance product because it's going to cost a lot of money to have all these discovery fights. And it's just going to be another way to fight the war of attrition. The last thing I wanted to touch on is just this thing about the Chinese Communist Party is using litigation finance to, you know, like whatever, you know, mess with the United States. Nobody is more concerned about China than I am. I mean, truly, I have deep concerns. We don't need to talk about those today. But I just find this concern to be completely baffling. I mean, one version of it is that the Chinese Communist Party is going to steal trade secrets. Okay, if they want to steal trade secrets, they're going to send Chinese spies to work at companies with trade secrets, and they're going to steal trade secrets. That is how it happens. These cases have been charged by the Department of Justice. The Chinese government has a playbook for this sort of thing. They use university researchers. They are not going to invest in a for-profit litigation finance fund in order to do this sort of thing. And that's then going to hire a law firm, that's then going to sue a company, that's then going to get a trade secret in discovery, and somehow all of that's going to end up back with President Xi at the end. It just doesn't make any sense. If they want to fund vexatious litigation, which is another version of this, that they want to just harass good American companies, something I'm fully prepared to believe they would like to do, they're not going to, again, they're just going to give someone money to pursue vexatious litigation, right? They're not going to care if they get a return. I mean, if the Communist Party is trying to fund cases to hurt American companies, they're not going to be, asking Daiwa and Burford and me, well, what's the IRR? We're only going to want to do it if we get a 25% annual. I mean, it's silly. And if they're pursuing, and then finally, any funder who is doing that, or any lawyer who is acting at the behest of the Chinese Communist Party, needs to register as a foreign agent under the Foreign Agent Registration Act, which is something the Justice Department has aggressively enforced. And so for all those reasons, and I think the other 2 points that were made were the sovereign wealth funds. I mean, if the sovereign wealth funds are just investing for a profit, I don't know why that is something we should be concerned about. I mean, if they're trying to make money, then they are necessarily prioritizing a return, and that doesn't strike me as problematic. And then we talked about the Shenzhen Purple Vine case. I don't know much about that litigation, but if they're funding meritorious IP litigation where the patent has been breached, that seems perfectly fine. We shouldn't have a problem with good cases being funded. And if it's a frivolous case, then the lawyers should be sanctioned. And so I don't know. I don't see an issue here, but I'm happy to yield back the rest.
Daiwai, when you are getting the information about and making investment decisions on which commercial litigation you're going to become involved with, what type of information are you looking for, and are you ever concerned that you're going to compromise the attorney-client privilege?
So it depends on the stage of the case. I'd say about half of our investments happen after the case has already started. So there we have the docket, and we look at the pleadings, the briefs, et cetera. We also interview the lawyers and the client. We ask for the key documents in the case. We interview them about what happened. We may ask for references. We do a full counterparty due diligence. We're in background checks on everyone we're in business with, that kind of stuff.
And do you get periodic updates about the case? And again, are you concerned that those updates are going to be somehow utilized to challenge or compromise the privilege that occurs between client and lawyer?
So we get updates, and we have common interest language in all our agreements just to extend the common interest privilege. But we also asked to, not that people don't want to give it to us, but just to be clear, we say, if you're going to send us something, like let's say someone wants us to review a brief, right, which I don't have time to do. But if they're going to send that to me, I say, make sure you take out any attorney-client comments from the margins, anything. I only want to view pure work product, because we're pretty comfortable that work product protection extends to us, given that we have an alignment of interest. There's no risk of disclosure to the defense. And so generally we limit it to work product, and in light of that, we're not worried about invading the privilege.
And what type of return are you looking for your investor?
For our investor, I'd say folks that invest in our fund are looking to achieve greater than a 20% return on their money, which means that when we invest in a case, we have to charge more for that because the winners need to cover the losses. Just a little more insight into our model, which will help you understand it, I think, is when you think about a litigation funder, winners cover the losses. Well, it depends how big your wins are and how big your losses are, right? So our model is generally, if we're going to lose, we want to lose cheaply and early. And so what we try not to do is get in situations where we bet everything, have to spend the full budget and go to trial and then lose, because then that loss is much more expensive and we need to win a bunch more cases just to cover that loss. I'll give you just a quick anecdote. This is before my time at Parabellum. We invested in a patent litigation. And the plaintiff thought his case was worth $1 billion. And on the courthouse steps, there was a settlement offer for something like $100 million. So I'm going to swing for the $1 billion. We had no way to stop him. Go to trial, lose. But we had a pretty good appeal. So now, will you guys finance the appeal? Will you pay for that? Sure, we pay for the appeal. We win, it gets remanded. Now it goes to trial again, and then we lose again. And so now we could have settled. If we controlled it, it would have settled for $100 million. We would have got out, and we would have been fine, gotten some modest return, because we would have had to cut the hell out of a return in order for the plaintiff to accept it. Fine, but it would have eliminated that trial risk, which instead kind of tripled our loss and made it much harder to deliver that 20% to our investors from the rest of the cases.
Do your contracts take into account, or do the funding take into account the trial loss? Like sometimes in a plaintiff's case, the plaintiff's lawyer might say, if you settle the case prior to suit, it's this percentage. If I take it to suit, it's this percentage. And if I take it to trial, it's a higher percentage. Do your contracts have a similar type of scale?
Yeah, and lately I've been actually kind of doubling down on this, where I make the funding actually extremely reasonable, better than all my competitors until the point when it goes to trial. And then when it goes to trial, because the risk increases so substantially, then our return will increase a bunch. And the idea here is because we can't control the litigation, I'm trying to incentivize the litigants to settle so that we don't go to trial and, waste everyone's time.
So Tripp, we have a lot of judges in the room. What type of information should judges be looking for from third-party litigation funders?
Thanks,
Or
Judge.
should they be?
Yeah, well, I think the answer to that question is yes. And one of the things that I think is different this year compared to last year is it seems like broad agreement here on some type of disclosure. And in the past, in the last several years, it's just been a no from the other side. And so I do think, I've never served as a judge. I did clerk for one for a year. He was an appellate judge. So we didn't deal with a lot of trial issues. But I'd like to think of what it would be like to sit in each of your chairs in trying to decide how to handle a case that's in front of me. And so one of the three things that I think why disclosure is good for the courts and for the parties are conflicts. Some funders are publicly traded. It's a possibility that you may actually own stock in one of these funders. Not always likely, but it's a possibility. A lot of funders, judges have a lot of relationships outside the court, and I think it would be important for the court to know who the funders are to see if there is the potential of a conflict. So it's conflicts would be one reason. The second reason is control. We've talked a lot about it today. The bottom line is, on our side, we have so little visibility into what those contracts actually say to know how much control the parties would have. If I'm a judge, I want to know when it's time to resolve a case, if I have everybody in front of me that will be making those decisions. And with disclosure, you'll know who those parties are who have a direct financial stake, not a cause stake, a direct financial stake in the outcome of the case. And the third reason are cost, proportionality. Rule 26. In the litigations that I've been involved with and I know Aviva's involved with, the cost of discovery are overwhelming. And now in federal rules and there are many state court rules as well, one of the appropriate things for courts to consider are the resources of both parties. And that's why it's important to know if there's a funder and what the funding is, when the decision's made, who's going to pay for this, multi-million-dollar collection of documents. So those are the three reasons that I would encourage courts to ask about it. I think one of the proposals that has been made by certain organizations is in the federal courts under Rule 16, that first conference, that it's surfaced. I actually have a meeting of the parties later this week in a case I have in Texas. I will surface it, and then we'll raise it before the court when we have our hearing in December. So.
Aviva, how are the concerns that you raised regarding this mass tort litigation not already prescribed by the prohibition on sharing fees with non-lawyers or lawyers or non-lawyers practicing in a jurisdiction without a license? So this advertisement that's happening, why hasn't Johnson & Johnson or somebody else challenged these mass tort people and say, you're practicing in North Dakota, Virginia without a license?
Yeah, so I think the easier answer is that they disclose we are not lawyers, right, on these advertisements, right, in little letters, right? We are a referral service, and so they're allowed to do it. I think that certain states, individual states, have passed legislation around lawyer advertising, particularly in the drug and medical device space, to protect the consumer. West Virginia is one, and it was challenged, actually, went up to the Supreme Court. And on First Amendment grounds, with the idea that regulation around this kind of advertising, particularly in the drug and medical device space, needs to happen because of consumer protection. So I think courts, jurisdictions are getting there in terms of thinking about how this advertising is happening. One question I frequently get is, if the advertising is so terrible and pervasive, why aren't these alleged victims complaining to the local bar association about lawyer advertising? Right? Well, I think when your family member dies from a stroke because of lawyer advertising because they were scared off of their medication, your first thought is not, I should call the local bar association. And so that's why we're not seeing it in that space. I think that regulation around lawyer advertising with the considerations of the First Amendment are very important. And I think as lawyers, as a bar, right, we all have a responsibility to make sure that's happening for the protection of patients.
How about the prohibition on sharing fees with non-lawyers?
I think it's something that continues to have to be discussed because we have no insight into what these contracts look like, what kind of impact they really are having on particular litigations. We don't know, right? So we don't know what this fee sharing, what it looks like, what it doesn't look like. I think one thing that's really interesting, and to add to Tripp's 3, I would add a 4th, which is to protect your protective orders, because something Jaiwei said really struck me. He said, we ask for key documents in the case. How are you getting key documents in a case? Key documents that are subject to protective orders. So I think as a 4th to Tripp's, I would say, as judges, that's something that you should be thinking about.
In the ABA document, one of the things that they said that these funding outfits are trying to, the way that they get around the prohibition on sharing fees is that they take the fee not from the attorney's share, but from the actual settlement or judgment.
Yeah, so think about what happens.
They frame the
then.
contract in
Yeah.
a way that they take it above and beyond what the attorney will collect.
So think about the individual plaintiff, right? Who should be the focus of all of these litigations, right? It should be the plaintiff. So the plaintiff gets a recovery of their $100. They're paying, if they go to trial, up to 50% of that. First, they're going to pay costs, then they're going to pay their lawyer's fee, and then they'll take the funder fee on top of that. So what's the actual plaintiff ending up with at the end of the day? All of these things are things we don't know. We don't have insight into because we don't know what these contracts look like, and the plaintiff themselves probably has no idea what these contracts look like. We know that's true surely in the mass tort space when the contracts and these huge amounts of funding aren't necessarily used to pursue an individual case, but to create an environment for a mass tort to be successful.
Just very quickly, I just want to be clear that there's, just so we don't blend too many concepts, in the mass tort space or in any type of litigation funding, there's generally 2 types of funding. One where the funder is in privity with the actual client or the plaintiff, and one where the funder is in privity with the law firm. So I think let's use the tort space as an example. There's a whole industry of kind of what I'll call micro lenders that will give money, like the judge described, for living expenses and stuff like that, for personal injury cases, sometimes for torts. It's just a couple $1,000s per transaction, and that's going to come from the plaintiff's share because they're receiving the funds directly. Most of the dollars are spent giving money to law firms who then run these ads. Some of the law firms on leadership also take funding, but generally, when the lawyers get money, it's to run ads and support the overhead of their practices. In that case, the funder will just be taking from the lawyer's share. They won't take anything from the client's share. But to Aviva's point, the lawyer, when it settles the case, is going to think about its own obligations, and she's concerned that the folks who are giving money directly to the lawyers are creating conflicts of interest. And to that, I would just reiterate James's point, which is that in a non-recourse world, there's much less potential for conflict of interest. And just to layer on something I said at the beginning, the plaintiff's bar has been debt financed for decades. And there's nothing new about that. This problem has been around, so have the conflicts. The difference, though, is a change in media and advertising, which I'm not really involved in that, but I will say I have seen a Camp Lejeune ad or 2. But there are issues with that, right? And there are ways to rein that in and regulate that. But generally, just important to keep in mind, there's the lawyer-directed funding and the client-directed funding. These are different things.
James, you don't want to disclose your funders or what you're doing, but are there should the types of litigation funding vary as far as disclosure? For instance, in the mass tort world, should there be disclosure in the traditional tort world, but in the do-gooder group that you're trying to represent, should there not be disclosure because it would harm people from making those types of investments? And what I'm talking about is the type where we talk about where there's cause-based funding. Yeah. So you would prohibit or you would chill the speech rights of individuals funding women pursuing litigation to stop sexual harassment. That was the type of funding that occurred in the Time's Up campaign that happened. Should there be a differentiation for that type of funding in the courts for disclosure?
Thanks, Judge. I think that's a great question. And I just want to be, I mean, we are a for-profit fund, so we are not, we're not a nonprofit like the ACLU or Time's Up, just to the extent that wasn't clear, although we're trying to blend these concepts together. So, I think the first thing I would say is that there's a question about disclosure to who. So, I mean, I appreciate the corporate defense bar's concern for disclosure to the individual plaintiffs that they are generally battling in court, but I think there are real questions about what the client has to know. And so I think there you may have very good arguments, and the way to implement those arguments is through the ethical rules, right? And just say, I have ethical rules, the lawyer needs to tell the client what's going on in the case. There's all sorts of rules about clients. You can't do business with clients. You have a duty of loyalty to clients. And I think there is plenty of room to talk about what the state bars should be doing in terms of regulating a lawyer's interactions with his or her client about what's going on in a particular case. It is a very different question whether the lawyer or the client should be obligated to turn over all kinds of financial information to the large corporate defendant that they're currently doing pitched battle with in court. I do not agree, contrary to and I don't mean to hurt the kumbaya moment, but I do not think there should be any mandatory disclosure, at least based on the arguments I've currently heard in any of these situations. And I'll just go through every explanation that's been given and why I don't personally, at this point, find it persuasive. So the first is conflicts. The judges in the room should not invest in litigation funders. I think that is a fairly obvious and prudential point. If y'all own shares of Burford, I would probably get rid of your shares of Burford.
I don't know, the returns are pretty good. You might want to talk to your advisor before talking to James about
Then
that.
y'all should have Tripp manage a blind trust. He knows who the best funders are, and then you're not going to have to worry about it at all. On this thing about being friends with the so look, my close friends in the audience, if you don't know the funders there, how could there be a conflict? It just doesn't make any sense. I mean, it's like if your best friend is a major shareholder in Apple, and you have an Apple case in front of you, but you don't know your best friend is deeply invested in Apple. I mean, it's just not a real conflict. And so it's like we need to find out if there's a conflict so we can tell if there's a conflict. It just doesn't hold water. At the most, you could ask for an in-camera disclosure of this, but I just don't see that being as useful or relevant at all. On this control thing about who has a financial stake, again, lots of people have a financial stake in a plaintiff in a contingent fee funded case, right? The plaintiff's lawyer is going to have debt lenders, they're going to have mortgage holders, they're going to have all kinds of people, staff, depending on them to win the case in order to get the contingent fee that's going to pay. And so all those people have the ability to pressure the outcome of the litigation. And by the way, on the public interest side or the trade association side, all kinds of non-parties have huge influence. So when a trade association has to decide how to litigate a case against the government, there are non-parties who are funding that litigation who are telling the trade association how to litigate the case. This is how it works. Because those are the people who really care, and that's the people who the trade association represents. When the ACLU brings a big, high-profile case, oftentimes they'll have a couple donors who are funding it, who care a lot about what happens. You think the ACLU is going to care what they think? Yeah, because they're repeat players and they're major funders of the group. No one here, I don't think, is advocating for disclosure in that context, and I just don't understand why we think the financial incentive, as opposed to the ideological incentive for the ACLU or the business incentive for the trade association, is somehow magically and categorically different. I think in all these cases, we recognize that it just doesn't matter unless the third party is the real party in interest, which is often the case for an insurance company, but is I think basically never the case for a litigation funder like we're talking about. On the cost and proportionality Rule 26 point, I haven't thought about that one quite as much, but again, I don't think we normally require Motley Rice to file its balance sheets for every year to figure out who has more resources in the litigation. And so I think maybe there could be some targeted thing if the plaintiffs are trying to say that they're impoverished, and there's reason to believe they're not. But that's something that could be dealt with in a very precise way on a case-by-case basis in the context of litigating a Rule 26 dispute. The final point on the protective orders, if you have a protective order, you should admonish the lawyers that violating the protective order will be extremely bad for the lawyers. And if there's any ambiguity about what the protective order means, clarify the protective order. But just knowing that there's a funder isn't going to do anything one way or another for enforcing the protective order. So,
We do have a question over here. Go ahead.
Very fascinating panel. Thank you for your time. The thing that I was most interested in was the comment that in the Cisco litigation, that Cisco has assigned their claims to Burford, who is now the real party in interest. And it almost made a light bulb go off and say, is that where this is ultimately headed? If we have this panel 10 years from now, are we going to be in a place where if we normalize this behavior and the traditional prohibitions against champerty come down, that instead of having a plaintiff who is funded that what happens is the plaintiff just assigns their claim to a funder, the funder becomes the real party in interest, and legal claims start to get bought and sold just like mortgages on a secondary market.
They already
Any
are, Mark.
possibility?
Yeah, they already are, Mark, right? There is an entire secondary market for litigation funding already.
And accounts receivable are assignable, claims are assignable, but to answer your question, no, that's probably not where this is heading, because why would there be a market for that? Look at what happened and how tortured it came to get to that result in Burford v. Cisco. Keep in mind that, like, we talk about control. We don't know, funders could be controlling. If you're a plaintiff in a litigation, why would you agree to give up control? They don't. Even if we could have control, no one would give it to us, just like they won't sell us their very valuable claims unless we can get it at a really good price. But the market dynamics do not support, assignment of claims, particularly when you need the actual assignor to support the claims, right? So, like, it's very difficult to buy, kind of what I'll call private disputes that are not wrapped up in an MDL where there's common facts that affect thousands of parties, because you need the plaintiff to show up at the deposition and to support the litigation to really help you with your case. And in cases where you're going to need them to go up and testify and help out, like, it's very hard to structure something where the interests will maintain aligned.
Well, and you already have in some contexts in the insurance defense world where you get an excess verdict, that claim against the insurance company becomes assignable from the plaintiff. And so this already happens to some extent. So, Tripp, you wanted to make one more final comment?
No, I'm good.
Okay.
James and I need to go tie up in a back room and see who comes out on top. And I'm not
All right,
really-
well, thank you all, and we've reached the end of our time, so.
Thanks, guys.
Sorry to
Thank you
be-
to Judge Traynor
miss
and
you.
to all of our panelists for participating in that panel. We will revisit TPLF tomorrow morning, again, in the kickoff panel for tomorrow morning, talking about what judges should think about this and the kind of ways in which judges can react. So with that, there is one error in a typo in your program. Lunch is from 12:15 now until 1:45, so please do plan to be in the room that entire time. We are going to have Professor Richard Epstein giving the keynote presentation during the lunch, so head on over just across the hall to lunch, and in just a little bit, we'll turn it over to Professor Epstein. Thank you.